Hello everyone, welcome to ManoVidya IAS. Today we will look into the Sabarimala case verdict and the whole issue associated with it. Let's look into the context in which the issue has arisen. 2 days ago, the 5-judge bench, which was reviewing 2018 judgment, has referred Sabarimala case to 7-judge bench so that it could deliver an authoritative pronouncement regarding role of courts in religious matters. Before getting into the details of the judgment, let's go back to the background of the case, which is very important to understand current judgment. Sabarimala temple is an Hindu temple dedicated to Ayyappan, which is situated at Sabarimala in Pathanamthitta, Kerala. Now let me tell you an interesting story of Lord Ayyappan. He was an abandoned son of Shiva and Mohini, an incarnation of Vishnu, and he defeated Mahishasuri. Suddenly, Mahishasuri turned into a beautiful woman and proposed Ayyappan. As Lord Ayyappan wanted to become Nastika Brahmachari, he refused her and went to forest. Even today, that woman is worshipped as Mallika Paradamma at a neighboring temple. Every year, nearly 40 to 50 million devotees visit the temple after observing 41-day period of abstinence. Since Lord Ayyappan is a celibate, women of menstruating age, especially at the age of 10 to 50 years, are banned from entering the temple. This has led to arguments in favor and against the entry of women to the temple. Now let's look into the arguments against temple entry. First one, Lord Ayyappan is a Nastika Brahmachari. This nature of deity is a vital reason for imposing a ban, and even presence of women deviate men from celibacy. Second one is women can't observe 41-day period of abstinence before making a pilgrimage. This is because of physiological and biological nature of women. Third one is ban has been imposed since time immemorial. Here their argument is ban has been imposed much before the arrival of constitution. So constitution cannot abridge the age-old custom. Fourth one, constitution has provided Article 26. Article 26 assures every religious denomination to manage its own affairs. So it violates their fundamental right under Article 26. Next one, constitutional morality in a diverse society gave freedom to practice even illogical custom. Here, if you can observe, we even practice many illogical customs in our day-to-day life without even thinking about the logic behind it. Next is Kerala Hindu Places of Public Worship Authorization of Entry Rules 1965 has mandated the ban on temple entry. Even the High Court of Kerala has upheld this ban in 1991. Now moving on to the arguments in favor of temple entry. First one, it is a discrimination on the basis of gender, age and their physiological and biological functions. It is against Article 51A Clause E. Secondly, it violates Article 14, Article 15 Clause 1, Article 17, Article 19 as well as Article 25. Here, Article 14 deals with right to equality. Article 15 Clause 1 is right against discrimination based on gender. Article 17 is about untouchability. Article 19 is about freedom of movement. And Article 25 is about freedom of religion. Third one, Article 26 cannot override Article 25. This is because right to manage religious affairs cannot override the right to practice religion itself. Fourth one, it denotes a patriarchal and partisan approach. Obviously, discrimination on women with respect to men is due to patriarchal mindset, which is still a major feature of our society. Everyone are equal to God. Now the thing is, we don't know whether God discriminates his devotees or not, but the people are discriminating in the name of God. So it subverts the idea of everyone being equal to God. Many social evils in the name of custom and tradition like sati system, untouchability, and Shani Singapore temple entry are the reforms which have been judicial or legislative. So here, judiciary can give a verdict with respect to religious evils. Now let's look into important cases of Sabarimala issue. Kerala High Court in 1991 has upheld the ban on entry of women to temple. Even it directed the government to use police force to enforce the order. In 2006, 6 women of Indian Young Lawyers Association petitioned Supreme Court challenging the validity of the ban. In 2008, the same case was transferred to 3-judge bench. In 2016, the case was transferred to 5-judge Constitution bench. In 2018, the Supreme Court judgment with 4:1 mandate has observed the ban as unconstitutional. and it has cited violation of Article 14, 15, 17, 19, and 25, and also argued that patriarchy nature of society is responsible for the ban. CJI observed that temple draws fund from CFI, that is Consolidated Fund of India. So it is a public place of worship and there is no concept of private mandirs. It also observed that Hinduism is not a religion but a way of life. That is why practice cannot be dictated only and narrowly by religious pundits. Religious practices must remain relevant to changing social structures and relationships. So it needs reform from within. Now let's discuss about the current judgment. Due to huge influx of review petitions against 2018 judgment, Supreme Court set up 5-judge bench to decide on these petitions. But 2 days ago, with a 3:2 mandate, this 5-judge bench has referred case to 7-judge bench seeking an authoritative pronouncement regarding role of courts in religious matters. It even referred few questions to 7-judge bench and are: what role can a court play in deciding whether a particular practice is essential or integral to a religion? Secondly, should essential religious practices be afforded constitutional protection under Article 26? Third one, to what extent judicial recognition be given to public interest litigations filed against religious practices by people of other religion? For example, the question is regarding what if a Muslim files PIL against temple entry or a Hindu files PIL against mosque entry? But here, Justice Nariman and Justice Chandrachud have a dissenting viewpoint. Their argument is, first one, they should have upheld earlier judgment, that is 2018 judgment which allowed women to enter the temple. Secondly, constitution is highest law and it should be given higher priority over obscure religious practices. Third one, constitution should be only holy book. So demands of orthodox religious organizations cannot be entertained at the cost of constitutional principles. Chief Justice of India even referred many cases in his judgment and are entry of Muslim women to Dargah, entry of Parsi women married to non-Parsi to Agyari. Here Agyari is Parsi's fire temple. Female genital mutilation in Dawoodi Bohra community. So his argument is, once we find the proper role of courts on religious matters, all these cases can be resolved with an authoritative pronouncement. So on a larger view of the case, it is an interplay between individual right to worship and right to religious groups, as well as religious freedom versus other fundamental rights like Article 14, 15, 17 and 19, and even right to privacy with respect to female genital mutilation. Here, the need of the hour is protection of women who enters the temple. And also, it is the time to evolve a proper judicial policy regarding this issue in order to provide a complete justice to particular gender and society as a whole. Now, it is the time to wait and look forward to the verdict of 7-judge constitutional bench. That's all in this presentation. Hope it will be useful for you. Thank you very much. This video is presented to you by ManoVidya IAS.